Hello and welcome, everyone. It's nice to meet you. As Alex mentioned, I am a colleague of Brian Sylvester. I am a lawyer at Perkins Coie and a lecturer at UCLA Law, where I teach a course on food litigation. And so today we'll be talking both about, let's see if this works. Oh, yes, it does. That was a little preview. So today we'll be talking both about litigation risks and regulatory risks facing the cultivated meat industry. But let's start with food. Let's start with food. The increased scrutiny of food labeling and claims generally. And is it okay if in the back I walk a little bit? Fabulous. I'm going to walk and try not to fall over. So, these are food labels, right? This is an exercise I do with my UCLA students. These are food labels, correct? Yes, great. Have folks seen these food labels before? Yes, fantastic. These food labels were the subject of a lawsuit. Let's start with this one. Why do you think they got sued? This says butter, okay? It says butter, okay. Anything else? So, okay, it says vegan butter. Now, those who said butter, isn't butter qualified by cultured and vegan? Is that sufficient? Maybe, maybe not. This was one that was a First Amendment suit involving the California Department of Agriculture. And as you already may know, they changed a number of aspects of this label in response to the suit. Stuff like vegan, stuff like cultured vegan, made from plants, very strong, very clear there. Cashew cream fermented with live cultures. What about this one? Are folks familiar with that product? And forgive me, my jokes, they may be very cheesy today. I know, I crack you up. All right, so, the Cheez-Its. This product was the subject of a lawsuit. Why do you think it got sued? Okay, it says 100% real cheese. That could present a real problem. Okay, what about whole grain? How much whole grain do you anticipate was in that product? Is it 100% like the cheese? No, I'm getting some nodding and some nodding off. That's about right for the afternoon. Okay, so in this case, this is a case out of the Second Circuit, the layer below the Supreme Court. And that case had to do with whole grain. What was the quantum of whole grain in that product? And on the back, it clarified, this is the amount of whole grain in it. And in that case, they talked about how a reasonable consumer might look at a label and whether they are expected to turn the label around. What about this one? I know, it's nuts. So, almonds, almond milk, right? Does that come from cows? Oh, we're unclear. Oh, that's unfortunate, because we might be confused whether this does indeed come from cows or not. That was the subject of that lawsuit. All right, so moving right along to this next set. How about this one? Does this product cut the mustard? Here, you have an allegation about place of origin. You have some French curlicue writing. You have this word, that which predates the founding of the United States, Dijon, a region of France. This was a case out of the Central District of California in LA. Ben & Jerry's. Here, the cow is pictured as relatively happy, and the allegation was, does all the ice cream that Ben & Jerry's uses, is it made with happy cows? I'm not gonna say anything about whether I have beef with that case or not. Okay, and this one. This is an interesting one for this audience in particular. What is this product? Okay, I'm getting some, for the folks on the live stream, there was hushed whispers and gasps across the crowd there. They've never seen this product. Well, let me sprinkle some truth. In this case, it was 100% grated Parmesan cheese. And this was a case out of the Seventh Circuit that was, again, the appellate courts right below the Supreme Court. And Justice Amy Coney Barrett was on the argument for this. What do you expect that to be? Cheese. Cheese. What does it say, though? What does it say? It says Parmesan cheese, okay, which qualifies the cheese. But what else? 100% graded. Excellent. That is grade A right there. So 100% graded. So is it 100% graded Parmesan cheese? Or is it 100% Parmesan cheese? So in this case, it was a shelf-stable product, right? There's other things in the product, right? There's other aspects of the product. It's shelf-stable. The scientists in the room can explain, particularly to me, how you get cheese to be shelf-stable for a long period of time. But suffice to say, normally it needs to be refrigerated if it was 100% cheese, especially in graded form. So that product does not contain 100% cheese. So we're seeing a lot of cases these days, things like 100% juice, 100% this. And so these kind of claims, these are just this is, for lack of a better word, a flavor, a taste of the kinds of suits that are out there in what I do, which is food labeling and food litigation. Over time, from 2008 to then, we're seeing where do you think this general trend line is going? It's going up. Fabulous. Line goes up. Fabulous. So our firm, we collect from nationwide courts all over the country, these suits against food and beverage companies, and we're seeing an increased number of them over time. And there we are here in 2023. So this has largely, I'll go back up on the podium. So the increase of cases, food litigation cases, have transformed the food industry more generally. And this is the framework, the sort of setting that this industry is really coming into, right? Getting in as it moves towards market. One other aspect of it moving towards market, of course, as you may have talked about earlier today, is what even to call these products, the nomenclature used. And this is just one example of the kinds of studies that have been done about this. This one is in particular in the Nature series of journals, so this one's in the Science of Food, but it's just one example of the types of studies. And they studied cultivated, cell-cultured, lab-grown, or artificial, cell-cultivated, grown from animal cells, not farmed or fished, and this term, which the researchers simply made up. So don't feel bad if you didn't know that one, because no one did, they made it up, right? And so they decided that they were going to study what folks understood these terms to mean and whether consumers could accurately understand what these terms are trying to convey. Among other things, this particular study, which again is one of many, found, if I could click, oh, there we go. They found a number of findings. In particular, whether folks were correct, incorrect, or didn't know the various terms. One central finding was, conveniently, the term that they made up, folks didn't know. That makes sense. That tracks. But you're also seeing significant folks getting it correct between cell-cultivated, cultivated, cell-cultured. I mean, you're seeing large numbers here. Of course, much smaller on the one they made up. But this is not the only study, and there are many studies, but this is increasingly seeing traction in the literature about our folks understanding what these terms to mean. How does this relate to what we were talking about before? Right? What we're talking about before is, are consumers confused by labels? Right? Are they suing about labels? This is, and what should regulators call them? Right? So this all factors in, all leads up to that. Right? And then you see nearly 100% getting it correct about a description of the product, that it was grown from animal cells, not farmed or fished. But again, this is not the only study. It's not the be-all, end-all study. It's just an example of various studies. Another set of research studies are out of the Good Food Institute. And the Good Food Institute has done good research over many years, including this one, about how consumers understand these types of terms. They talked about slaughter-free, craft, clean, cultured, in terms of appeal, in terms, oh wow, that was pop, appeal, descriptiveness, differentiation from conventional meat products. They've done additional work since January 2020. There were some intervening events between 2020 and today might have been aware of. But in terms of appeal, differentiation, and descriptiveness, they've recently found in study published in December 2022 that cultivated and cell cultured performed the best in their studies. In particular, cultivated meat was found to be 2 times as appealing as cell cultured when looking at ingredient lists, and 4 times as appealing when just based in conversation with individuals. So we've talked about some consumers, we've talked about some consumer-facing studies. Let's talk about the regulators. Everybody's favorite, the regulators. USDA, FDA. What do they regulate? Who, what, and why? How? Any basic interrogatory you can ask. So USDA, U.S. Department of Agriculture, regulates pursuant to certain statutes, the Federal Meat Inspection Act, FMIA, the Poultry Products Inspection Act, the PPIA, as well as other statutes like the Egg Products Inspection Act. And the FDA regulates essentially everything else. There is a curious case of catfish, which swam from this regulator to that regulator in recent years. If anybody wants a really fun law review article, I commend you to that one. But the USDA regulates essentially 80% of the food market under both the large food, the federal FDC&A Act, Food, Drug, and Cosmetic Act, and the Public Health Services Act. Does anybody know, can anybody hazard a guess about how food is defined in federal law? Anybody want to guess? What makes food food? Okay, that's great. That was great in the back. Don't know if you're a lawyer, but that was really close. Yes, so food as defined in federal law, which is as defined in the Federal Food, Drug, and Cosmetic Act, passed in 1938, articles used as food. Correct. In addition, chewing gum. And ingredients in both chewing gum and the first one. So, FYI, that's a fun one. So, FDA regulates food and food additives, and USDA regulates a certain subset, particularly with regard to what is called USDA amenable species, things like poultry and meat. So, how does this relate to cultivated meat? I'm so glad you asked that. So, this all leads up to the cultivated meat, the formal agreement between FDA and USDA. Those are the ones that we just talked about before, that's right. Okay, so FDA, USDA. So, FDA, they handle pre-market consultations, evaluating production material processes, and they do pre-harvest inspections and related activity. At a certain point, for that subset of USDA amenable species, oversight will transfer at point of harvest to USDA's Food Safety and Inspection Service, USDA FSIS, which is a mouthful. But USDA oversees post-harvest inspection and product labeling for those particular products. But what about the other set that are not USDA amenable, non-USDA amenable species? FDA will retain that oversight, largely from fish and seafood, except for catfish. So just watch out for catfish. No one wants to get catfished. Okay, so both agencies share information and will coordinate. So there was a formal agreement, this is 2019. This is now developing over time. How is that developing and how is that relating to labeling and advertising? Moving on, we'll get there, maybe, maybe not. There is another slide. Oh, there we go. Back one. Back one. Back one, that's right. So labeling and advertising for these products, USDA regulates labeling for cultivated seafood products, that is non-USDA amenable species, and USDA regulates labeling for cultivated meat and poultry products, that is the USDA amenable species. And then there's a formal memorandum of understanding between USDA and the FTC, the Federal Trade Commission. The Federal Trade Commission regulates food marketing and advertising. So what's on the label and the marketing, separated. And they share some aspects of this, but the FDA and the FTC will often coordinate on what's on food products, and then for USDA amenable species, there's a coordination with USDA for the advertising of those products. So a number of regulators in the mix. This is Perkins Coie Thought Leadership. This is Brian, who you just mentioned. This is me. Hi, me, and our colleague. And we have several colleagues working on this. We've been following what's been going on over the past several months. It's been a very active area. You may have heard some about this earlier today. But among other things, the USDA has issued new directives. That's a helpful, handy headline there. And they provided new updates for cell-cultured meat and poultry products. Yet, the situation remains sticky for many regulated businesses. Among these things that USDA has done is they've issued new directives and updated them with regard to food safety, sampling, inspections. One of the things that USDA does for the products under its regulatory ambit is it inspects, at the point of harvest, as well as it reviews labeling. So in terms of reviewing labeling, it is going to review and approve this kind of labeling. We'll get to that a little bit later. In the documents that USDA came out with, they also talked about certain facilities may be subject, particularly those for USDA amenable species, that do both pre-harvest, harvest, and post-harvest, those kind of activities. They might be subject to what are called dual jurisdiction. Dual jurisdiction is exactly how it sounds. Jurisdiction for the pre-harvest at the FDA and harvest and post-harvest under USDA inspection. So what's been going on? What's the status? Well, USDA recently issued grants of inspection, that is, we're going to inspect you, and approve the labeling for two companies, Upside Foods and Good Meat, so that they approve the initial labeling. And one thing to note, particularly with regard to the nomenclature, is that Good Meat noted in its press release that the word used was going to be cell-cultivated chicken. That may change, but we'll have to see. But that is what the USDA has approved, at least thus far. Okay, so let's think about what are the regulators thinking about? They're letting us know, they're letting us into their thinking with things like the Advance Notice of Proposed Rulemaking, the ANPR. It's a sea of acronyms. And in this ANPR that they issued in 2021, proposed by FSIS, that they noted, again, that labeling must be approved. FDA proposed subject labels to cell culture products under its jurisdiction USDA amenable products to the same processes as special statements or claims. And one of their guiding questions was, will this new method of production or processing align with consumers' expectations? Does it align with consumer expectations? Tying it together, talking about the expectations that consumers have throughout this presentation, right? And if it does not align with consumer expectations, new labeling requirements may be needed. So we talked about FDA, we talked about USDA. In fact, both agencies have come out with this kind of rulemaking thinking, the USDA's ANPR and the FDA's request for information about cell-cultured seafood products. There's a variety of questions here, such as product name, regulatory standards of identity, amending the regulatory definitions of meat, meat byproduct, meat food product, and others, and what kind of label claims are going to be used. These are the kinds of questions that USDA posed, and when they posed it, they got over 1,100 comments from stakeholders. The agency is taking this under advisement. Here are some takeaways, key takeaways, which are helpfully rather small, but that's okay. And so that noting that the comment period is closed, right, and that this is an advance notice of potential rulemaking, proposed rulemaking, so the timeline is relatively opaque moving forward, but these comments are in. We know that that USDA is reviewing labels because they too got approved, even during the pendency of the ANPR. And USDA's activity here could influence FDA's use of the naming conventions. These things are linked. The regulators are talking to each other in part because of the formal agreement in 2019. But we know that these folks are talking to each other. We know that they may be influencing each other in terms of naming conventions and key terms. And broadly speaking, the U.S. public and the regulators are looking at alternative proteins and alternative dairy in general. And these may have questions in common with how the USDA and FDA are looking at alternative proteins more generally, alternative dairy more generally. As you may or may not know, earlier this year, there was a draft guidance from FDA about plant-based dairy and the labeling thereof. So that would just be top of mind, that these could be distilled in sort of key principles to keep in mind when you have a conventional product derived from an animal, and those that are either not derived from an animal or have a alternative means for being derived from an animal. It boils down to the key axiom of food labeling law, which is that labels have to be truthful and not misleading. So there are many ways that regulators get there, and in terms of this, they are thinking about it in that way, and that may be affected by how they're thinking about plant-based milks as well. Okay, so we've talked about the federal level, but there's also other levels here, states. States. Are folks familiar with Missouri? No response. That's okay. It is called the Show Me State, so there it is. So Missouri has a law that people may be familiar with. That law prohibits persons from misrepresenting a product as a meat when it's not derived from harvesters, production, livestock, or poultry. Okay? Do you think that has a poultry chance of being upheld? Oh, you might think my jokes are clucking ridiculous, but trust me, this particular law is a criminal law. So people can go to jail for mislabeling meat in Missouri. Whew, wild. So, as several folks launched a lawsuit here on First Amendment grounds, saying, you can't do this. We have commercial speech rights, right? And no one's being really misled here. Missouri ultimately clarified in a memorandum to prosecutors, right, that if the labeling makes clear that the product is alternatively sourced with an appropriate qualifier, think how we started about vegan butter, appropriate qualifier, then no enforcement action would be taken. And that missive here came with a footnote. This footnote: manufacturers of lab-created products, which is what their term, not mine, are encouraged to work with the Missouri Department of Agriculture on appropriate labels before attempting to sell lab-created products in Missouri. That is an important footnote. That is how you call burying the lead, Missouri. So just FYI to that footnote. But over a dozen states have these kinds of laws that have been enacted generally since the increased prominence in the market of alternative proteins more generally in the recent past. Arkansas is another one. Arkansas prohibits persons from representing a product as meat or a meat product when the product is not derived from harvested livestock, poultry, or cervids. Don't ask me what cervids are, but there. So that was challenged by similar plaintiffs on similar grounds as Missouri. What do you think happened there in Arkansas? I won't spoil the surprise, it's already up there. On September 30th, the federal court blocked enforcement of the law as unconstitutional. So we have courts across the country reaching somewhat varied views on this, right? You have Arkansas and Missouri are fairly close together in geography, yet this lawsuit is ongoing and this one is enjoined because of this federal court's ruling. And Mississippi is an interesting example as well. In Mississippi, which is always fun to spell, Mississippi's law provided a plant-based, insect-based, or cultivated food product shall not be labeled as meat or meat food product, and even impose potential criminal sanctions for doing so. This is another one with potential criminal sanctions. How do you think this one ended? If you answered in your head that that this was settled, it was withdrawn after regulations were promulgated by the State Department of Agriculture in which plant-based foods were carved out of the statute, then you're right. So now there's a regulation in Mississippi where plant-based foods are treated differently than insect-based foods or cultivated meat products. So just watch out for Mississippi. Okay, so with that in mind, we'll move from Mississippi. All right, and just one quick thing is that it's possible that many states may take this approach in terms of appropriate qualifiers. Many may have not done so yet. Okay, we'll move from Mississippi to Louisiana. Louisiana is pictured here, and there's a law on the books in Louisiana, and I will wrap up quickly. I just saw that my time is out. But in Louisiana, there was a law passed saying that you cannot represent products in the same way as Mississippi, Missouri, Arkansas. They're very similar laws, some nuances here and there. But this one is not derived from various animals. Okay, so it's challenged at the district court level, which is a trial court level, and the challengers won. The challengers prevailed. They said this law is unconstitutional. The appellate court, the one right below the Supreme Court, and this is the most conservative, Louisiana and Texas have the most conservative appeals court in the country. They said, no, that law's fine. That law is not unconstitutional because under constitutional principles, First Amendment rights for companies are only protected when, or not protected when there are intentional and misleading speech at issue. So because this law only prohibits intentional and misleading misrepresentations of meat products, it's excluded. So another example of where appropriate qualifiers may be particularly helpful. So looking ahead, federal, state, and other, various ideas here at the federal level, thinking about, okay, we've talked about USDA and FDA, what about the FTC, what about imported, exported products, increased interest, remaining interest in naming and labeling of these products, as well as federal litigation. Continued litigation across the states, and these state laws that are very similarly worded about harvested production livestock, as well as we talked about earlier about how the USDA approves those labels. Typically in FMIA and PPIA lawsuits, there are preemption provisions there because the USDA has approved that label. So because it's approved, it cannot, by definition, be misleading because it's been approved. It remains to be seen for this set of products, the effective preemption provisions for this product, as well as other in terms of investment and patent litigation. But looking ahead, here are some select legal issues. And very quickly, I know I'm out of my time, but very quickly, bioengineered. So the National Bioengineered Food Disclosure Standard came into effect recently. So if there is there's a standard for disclosure for bioengineered foods. So if your product is a bioengineered food, which is a defined term here, I'm not going to read it out, but that, then you will have to put a disclosure on the label. The compliance date was 2022, so moving forward, these bioengineered foods need to be properly disclosed. Heads up on that. So with that, plug for my company, Perkins Coie, and their thought leadership across the country in the food and consumer packaged goods space. And thank you.